12, or it's a hung jury. When we sat there, we thought it was 11-1 against our client. We said, no way, we saw the jury, we rolled the dice, and it was 11-1 the other way. And we believe it was the police officer that was the holdout, and he came around. The jurors were from Mount Vernon, all over the Chappaqua, and I was proud of the jury because they heard it all. And it is very tough to get a fair trial because we've seen what the prosecution has done. You know, there's a lot of things we can discuss about what their strategy is for forcing these pleas and the things that they've done. So I don't know if there's any.
I wanted to, Peter, you on Facebook.
David, we need you to use the mic.
Yeah. Oh, here you go. All right. Well, let me stand.
Yeah,
okay.
right.
Peter, you on Facebook, you made a post about your defense of a client that was found not guilty, and one thing you said that the press doesn't cover when they're not guilty. Right. They only cover when they're guilty. Right. I want you to talk about that.
Well, you know that the district attorney's office, it's all political. It's a political position, and most people want to believe in this so-called criminal justice system, that it works, and they want to believe that when the police make an arrest, they've arrested the right individual. Unfortunately, that's what trials, or fortunately, that's what trials are for, is to make a determination of that. So anytime there's an arrest and a prosecution, there's a great deal of fanfare that they've made the arrest. We have the person that committed this particular crime. Channel 12 News, files, it's run in the Journal News, local stations cover it. But what they don't cover are the types of things that took place during police investigations. Improprieties, where false confessions were obtained, where individuals who can barely read and write are signing off on typed confessions that they did not type, where individuals are being interviewed in advance of being on camera and for an hour to 2 hours to several hours, and then they turn on the camera for a half an hour so-called confession. But they don't show what preceded that. So I had done a double homicide trial in the Bronx in June. Client sat at Rikers for 3.5 years. He went in at 18, he came out. We did the trial and he was acquitted of both homicides. No cameras. There are no cameras. I walked the young man out to the front of the courthouse. But for me posting on Facebook, nobody would have known that this young man was acquitted. But the case, when he was arrested with his co-defendant on the double homicide, it was all over the local news, it was on channels, TV channels, but they never seem to give the same amount of focus and attention, because there has to be the appearance to the general public that the system is working, that the system is working correctly, that we have the right person. And the system is very reluctant to admit that they've made a mistake. But that's what jury trials are for. That's what jury service and people, lay people coming out to serve on juries, to keep DAs honest. Because as much as they say, DAs, that our job is to see that justice is done, their jobs are really about self-fulfillment in terms of obtaining convictions. Because that's how they stay in office. And make no mistake that this is a business. Corrections is a business, police is a business. This is big business for the United States in terms of arrest.
Yeah. You want to say something?
Yeah, I think, you know, during the time that I have here, there has to be conversations, because we had a lot of hope in the new DA. You know, we had changes in the guard up there. I don't know what's going to happen and if there's going to be changes. So there needs to be a push to meet with him every week. I don't know if the NAACP meets with him, asks about cases. And the pressure has to be placed on, because I can tell you, just like my colleague said, it's horrific. Okay, it's horrific. I've worked, and sometimes my colleague doesn't get the respect because he's sort of, even though you had the stint as the ADA, you've done a lot of defense. So people will say, okay, you just defend, so you're going to say that. I have been on every side, and I have worked at the highest level of law enforcement. And I can say it is horrific. And I'm calling on the members of this committee or this organization to sit down with this new DA. Because what we saw in the trial we had, if that is something that they do, then we have a total abomination of the criminal justice system in Westchester. We had police officers who took the stand. The first cross-examination was how many convictions the police officer had. So that was the first thing. The first two police officers had convictions themselves, and some of them were convictions of assault without any type of disciplinary action. So those were some of the prosecution's witnesses. Some of the other prosecution's witnesses, they were given 6 months, and like I said, I know about Greenberg because the gentleman that was involved in our trial was a sex trafficker that was in Greenberg that skipped out of the courtroom because the prosecution offered him so little time to testify against our clients. This is the game. So we have these young men, and then they're saying, oh well, I just got 6 months. I have a gun charge. This gentleman had 2 gun charges, sex trafficking charges. They had to get him out of South Carolina. He was using other people's IDs. He was doing everything and received 6 months for testimony against my client. So, and we had something that was, and I have to say this because the people here have to know, we had something unprecedented. Because the prosecutor didn't know who we were. We're not really the regulars in the courthouse. So they weren't clear on who we were. So they began to give us stuff. And one of the letters that they gave us was one of the witnesses had written a letter talking about the police officers using tactics and harassing and going to his mother's house and all over the place and trying to get him to testify. He wrote a letter and the prosecution had to turn it over. And we'll talk about what has to be turned over. We'll talk about what they call this Brady. And they're not turning things over. They're not being forthright. We force the issue because these young men are being railroaded. And I don't say that lightly. I'm a little older than you, so I'm not here to say it. And I say it because I'm giving you the backup because I've represented. So you can't say that when I represented Elliot Spitzer, I'm right and everything I say is right. But when I say it about the criminal justice system, I'm wrong. So I'm right on both sides, and this is an abomination that we have to stand up for because innocent people are going to jail and they're taking time. I've sat in there when you've taken pleas. People are going 10, 15 years like it's nothing. And these are children, young men. And it's no joke inside. It ain't no joke.
I wanted to briefly follow up on something that you mentioned, which is Brady material.
Right.
Yeah. What that means is that prosecutors are required by law to turn over items which are considered to be exculpatory towards defendants so that they can present those items as a part of their defense. What routinely happens, and it's not only in New York State, what routinely happens is that DAs are very remiss and reluctant to turn over tools by which defense attorneys can use to get their clients acquitted. So what ends up happening is prove their innocence.
It can be used, for example, just to piggyback on that real quick. We had an issue with videotapes. My client, they allegedly saw my client doing things on videotapes. Those videotapes were lost. Every police officer that touched them, nobody knows where they are. They all go through this Ponzi, 3-card Monte type deal. Not only was one videotape lost that was of one location, another videotape was lost of another location, and then another videotape was lost, and then a particular photo array where allegedly someone pointed out my client, that was lost. We're talking about areas of insidious behavior because they're all lost. But we had to push the judge to let us know that early, because we wouldn't have known it. Normally, you don't get this information except right before trial. They have an obligation to turn it over to us when it's believed that not having it, it could show my client's innocence. They have an obligation to do it, but they make judgment calls saying we don't think that's what it is. So it's a mess. It's a mess.
So, let me ask you a question. Now, how do you guys fight it for your client? You know, because now a lot of people here, they're like, wow, we didn't know that. But how do you fight it if the system is that way, and as lawyers? You know, how do you fight it without, you know, I mean, a lot of us are just hearing about it now, right? So how do we move forward in fighting it?
Well, I don't believe that those items that you mentioned were lost. You know, that's a euphemism for saying that they were destroyed because they don't want their case destroyed, and they're not going to admit to the destruction of evidence because that's the kind of thing that they can be prosecuted for. So they're going to say those items were lost, but what's the probability of 4 or 5 videos and all being lost? It's slim probability. So they do this, they specifically suppress the exculpatory evidence or evidence that tends to show potential innocence on purpose to obtain convictions. But when you do that, you're really denying due process. You're not letting the system work the way it should work, because, as indicated, this is political, and they're about percentages. The federal government has something like a 98 or 97% conviction rate. They have that conviction rate because really the deck is stacked routinely in their favor. The feds tend to play a little bit, a lot more fairly, because they turn over things that you're technically not even entitled to in an excessive caution. And everything is done on the record. There are no sidebars that they do like in state court where they go off the record. Because the reason that they do that in state court is so that somebody can't review it for the purposes of appeal. Okay, because when they read the record, all that's on the record is that there was a brief sidebar. Well, what was discussed at the sidebar? If it's a legal matter, it needs to be on the record to be preserved for appeal, because that's the only way you're going to get an appellate court to review it, to decide whether or not there was a mistake here that occurred and whether somebody should be granted a new trial. So I see somebody raising their hand. They have a question.
I'd just like to ask that something like that, isn't that a crime? Shouldn't somebody be held accountable?
Well, we don't have a system, and I talked to some people that are part of an organization. They're trying to pass a bill which they're struggling to pass. And this was spearheaded by by a Caucasian man who was actually wrongfully accused of a certain crime. So there is legislation they're trying to pass to hold the prosecutors accountable. That hasn't passed. Of course, the DA's organizations are going to fight and fight it hard. But with the education of this organization and various groups, by sitting down and even talking to us later on about the things that, for example, in my case, we had rap music on trial. We have an expert right here, AJ, that we had to call in because my client had a rap video, and based on what was said in the rap video, they tried to connect him to certain behavior. AJ had to come in as one of our expert witnesses to talk about, I shot the sheriff. That person didn't go to jail because that's just, you know, a metaphor, you know. And rap is the only genre that you can, as you can say, I won't take your spot there, where you actually believe what it is they're saying. So, you know, they tried to tie him to a gang. So we talked about the Sugar Hill Gang. That's not a gang. We talked about Kool and the Gang. That's not a gang. So gang, just using the word gang, became an issue. It's on fire in there. Help us.
You know, you asked the question, isn't that a crime? Yeah, it's a crime. But look who's committing the crime. It's the people that are enforcing the law. Do you expect them to police themselves? Do you expect them to prosecute themselves? That's not going to happen. So when you ask, I mean, what is the greatest crime that people commit? Well, the greatest crime that police officers commit when they take the stand and they testify untruthfully is perjury. Everyone knows perjury is a felony. It happens routinely. It happened in the trial I was talking about when the cop said he saw my client going in and out of a skylight that you clearly could not see from the backyard of his house. And I put in the video. The DA didn't put in a single video. I put in video that I took. I put in photographs that I took that showed you couldn't even see the skylight. That's why the client was acquitted. And what happened to the officers? Nothing. Nothing ever does. They can blatantly lie in the stand, perjure themselves, and routinely. When was the last time you heard in the paper, the news, anyone being prosecuted for perjury? It is just known that this is what people routinely do in the stand. It's a shame, and it should open your eyes that just because somebody puts their hand on a Bible and says they swear to tell the truth, they don't. Okay, that's like, you know, curling your pinky and saying you're going to tell the truth.
Question?
Do I need a mic?
No, you can speak.
Okay. So basically the question is, what